Now, the prosecutor obviously has the discretion to either retry the case, or they could negotiate the case, or they could just dismiss the case. They're not going to dismiss a double homicide where you're looking at the death penalty. They're just not going to. And Melly probably isn't going to take any kind of deal, because any kind of deal that they would give him would be life without parole, and he's not going to do that.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, which means I'm experienced. I go to trial. I don't just hold your hand and write passports to prison. I am a board-certified criminal defense lawyer by the National Board of Trial Advocacy and by so I'm double certified by the Minnesota State Bar Association as a criminal law specialist and a criminal trial specialist. So, and I've been in these situations. Today we are going to be reacting to the Melly case and talk to you about what it means to have a mistrial and what it means to have a hung jury. But before we get to that, go to contractscounsel.com if you either need a lawyer or if you are a lawyer and you want to do some work where you can make a little dough from home and write contracts for clients who need your services. So go to contractscounsel.com. That's contractscounsel.com. And you can help a lot of people. We got plenty of clients, but not enough lawyers. So go to contractscounsel.com if you are in fact a lawyer, and if you need more information about it, just hit me up. We can get you set up, or go to the link down below and contractscounsel.com. So we're going to react to Melly. First, if you remember, about 7 hours into their deliberation, the jury had a question. And so let's go to the question first, and then we'll kind of dovetail that into what is going to happen later. The judge received a note earlier in the week, last week, in the Melly trial. And and a lot of times jurors have questions, and they can be anything from as mundane as, can we get another copy of the instructions, or can we get something to eat, or, we want to see a piece of evidence. And in this case, they have a question about being deadlocked. So let's see what the question is.
What I want to do is, based upon, I received this juror inquiry form that is signed by the foreperson that reads as follows. State of Florida versus Jamal Devins, case number 19-00-1872 CF10A. Check the box, ask the following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson.
So whenever they ask a question, sometimes if it's an innocuous question, the judge can just deal with it and send a note back. Like, can we get a transcript? And the answer would just be no, because there is no transcript. But in this case, when they have something like this, everybody has to be assembled. So they bring everybody back into the jury. The defendant is in the jury, or in the courtroom, the defense lawyers, the prosecutor, and the judge. And then they do it in open court. They read the question. Now, they've only been, at that point, when the judge got that question, they've only been deliberating for about 7 hours. That's not really enough time to cause a mistrial. So let's see how the defense reacted to that.
This decision that Mr. Adelstein brought something to my attention out of the Thomas case, which is a Supreme Court case, and it says, as noted, every Allen charge issue must be decided upon the particular facts and circumstances surrounding an individual case. So that goes to the issue of individuality and whether or not it should be tailored to the circumstances of the particular case. And we're taking a position that mirrors what the Supreme Court has declared, that modification of Allen charges is not foreign. As a matter of fact.
So what he's talking about is an Allen charge. An Allen charge, Allen is just a case. And whenever you hear like a Frank's hearing or a Daubert hearing, or in this case an Allen charge, they all relate to a particular case. And an Allen charge is basically the judge saying, okay guys, I know you think you're deadlocked, but you need to put a little more effort into this, go back and deliberate some more. So let's see. So we'll listen to the charge.
Supreme Court has directed that it should be tailored to the circumstances surrounding the individual case, so that we maintain our objection.
Thank you.
Thank you, sir.
So you want to bring the jury in?
Yes, sir.
Thank you, counsel. Please be seated. Let the record once again reflect the presence of the defendant, the defendants, the counsel, the assistant state attorneys, and the ladies and gentlemen jury. Ladies and gentlemen, two things. First, I received a note from my bailiff did. It's not signed by the foreperson, but it's a note that was handed to him. It says, "Are we allowed to have Apple Watches?" Someone has one from one of
And that's probably somebody being a tattletale in the jury room.
the jury. As I tried to explain to you earlier, all the electronic devices are basically, we're not allowed to have those in the jury room, so we asked our bailiff, Gary, to try to collect them. Does anyone have an Apple Watch, yes or no, in their possession? I asked the question, does anyone have one? No? I see everybody raising their hands, or several raising their hands showing they don't. All right, there's no Apple Watches. Thank you.
So that's kind of a dick move if somebody did that. Otherwise, whoever has the Apple Watch is not being truthful to the court, and they're putting it in their pocket. That's interesting.
Following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson. All right? So what I'd like to tell you, or read to you, is an instruction that's called Jury Deadlock 4.1. And it reads as follows. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on the facts of the case. Excuse me. There are two things.
So when you're back in the jury room, and and like he says, a lot of times an early vote makes it difficult for you to change your position later on.
That a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you have had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. Ladies and gentlemen, you may now retire and continue with your deliberations.
So if they can't come to a verdict, then it's a mistrial. And we'll talk about what happens if that's the case, which it is the case. So let's take a look at what happened later.
And ladies and gentlemen, ladies and gentlemen, see the juror inquiry form. It indicates that after further discussions, reviewing the evidence and speaking freely amongst the jurors, we are still unable to reach a unanimous decision. So at this time, what I'm going to do is just declare a mistrial, the case was mistried, and indicate to you that how much we appreciate the fact that you were here.
So they sent a second note into the courtroom saying we can't, and I don't know how many, it was like 17 hours later or however many hours, it was yesterday afternoon that they came up with, that they just couldn't come to a decision. And so the judge declared a mistrial. What happens next? Well, when you have a mistrial as a result of this, there's no conviction, right? but the charges are still there pending. So it doesn't get dismissed. So some people say, oh, you only need one juror to, no, you don't. You need all 12 to go guilty or not guilty, either way. Now, the prosecutor obviously has the discretion to either retry the case, or they could negotiate the case, or they could just dismiss the case. They're not going to dismiss a double homicide where you're looking at the death penalty. They're just not going to. And Melly probably isn't going to take any kind of deal, because any kind of deal that they would give him would be life without parole, and he's not going to do that. So, in all likelihood, they're going to have to try this case again. And where does Melly go when he's doing that? Well, he sits. He sits in jail like he has been this whole time. And how long has he been in custody? A long-ass time. He's been in there a long, long time. Now, can the defense move for bail after this? Sure they could. But I don't think... nothing's changed except for the timing of things. And one could argue that he's been waiting so long that he's, presumed guilty before innocent. And that is... But the court has the obligation when somebody is on a case like this to deny bail, generally speaking. And not an obligation, but that's how they come down. If they deny the bail, they can't be wrong. If they side with the prosecutor, they can't be wrong. You don't want to be soft on crime and be looking at re-election. And so it's an elected office. It's a public office with a public persona, and this is a high profile case. He ain't getting out. Period. Then after this, we got a little bit of a color play-by-play from the defense lawyers. Let's see what they have to say.
Just had the mistrial called, and I need to have both of your reactions.
Obviously, we want to thank the jury for their great efforts that they've extended over this period of time. But we are somewhat disappointed that Melly is not walking out the door with us. That's all I can say for right now.
And David, do you have anything you want to say further?
I don't really have much to add except to say that the jury did pay attention. We asked them to do a lot, and they hung in there and gave it its best effort, their best effort, and it's the most we could ask of them. So.
And what are your next steps as far as Melly is concerned? Are there going to be any efforts to try to get him out on bond?
We're not at liberty to discuss that at this point.
What are you at liberty to discuss? Can you tell us anything about next steps? Okay, thank you so much. We really appreciate you coming.
I like that. I like less is more. There's some guys who get out there and, grandstand or whatever, but these guys are to the point, and, both lawyers, I think, did a tremendous job. And I don't know if this is true or not. I think Melly's mom has said something like that the verdict was 9-3. I don't know how she would know that unless she talked to one of the jurors but here's the thing. Once the jurors are done with their service, they're done with their service. So these defense lawyers and the prosecutors could go talk to those jurors if they want to now, because they're not going to, when they convene a new trial, different jury altogether. And the nice thing about that is you can see what worked, what didn't work. And that would be very instructive for a new trial. So this has been our reaction to the mistrial declared in the state of Florida versus YNW Melly. We'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers. Make sure you go to contractscounsel.com if you are a lawyer, because they need lawyers. So go to contractscounsel.com and make sure you sign up for Patreon, follow us on Instagram, follow us on Twitter. Sign up for everything that's on our thing, because we suck. No, I'm just kidding. Make sure you follow us on Instagram, follow us on Twitter, subscribe, sign up for Patreon. We'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is at my God.